we we I get to oversee the Florida Realtors Legal Hotline, and one of the things I love about the hotline is the fact that you all call us because you want to talk about issues, but the important thing is that you help us by letting us know exactly what's happening in the industry in real time. And so it is the perfect barometer for what's happening. And so we have identified that a trend is emerging as it relates to criminal screenings. And so you may recall last year, if you've been around for a while, you may recall that we issued a member alert about this last summer. And we did a video for you all on this topic. And the thing about the industry is you will see cycles in housing trends, but also cycles in risk management. And this is a reemerging trend. And by reemerging, I mean this is a reemerging cause for lawsuits. So Jennifer properly identified that we see this primarily in the property management realm. But as you listen to the presentation today, I want you to think about this also from the point of view of homeowners association screening, condo association screening, not just tenants, but also potential buyers, right? This theory in housing, this disparate impact theory with the Fair Housing Act, can apply not just for the rental and the property management sectors, but also when it comes to people who go to buy properties and they submit applications to HOAs and condos and are screened by these folks. So it can have applications beyond just the obvious. So think about that as you're listening to the presentation today. So I'm going to ask, as I understand it, we're going to go about an hour here, and I'm going to talk for probably about 40 minutes, and then I'm going to leave room for questions about this topic or anything else that I don't cover, especially as it relates to fair housing, because we're seeing a lot of fair housing related risk management issues. Okay. So Jennifer, if I may ask you to please start the PowerPoint. I'll get into these topics. So moving forward here to the next slide, screening tenants with criminal backgrounds, the current low-hanging fruit again. And I covered kind of why I titled it that, because it is, again, low-hanging fruit for plaintiffs' attorneys. COVID has caused a dampening effect in many business sectors. Okay, not just restaurants and hotels and the travel industry and things like that we know well here in Florida, but think about the last time you might have heard, some of the more popular commercials for attorneys and law firms. All of the cute jingles that you would hear before COVID, you don't hear them anymore. Personal injury attorneys, things like that made a lot of money on slip and falls, car accidents. One of the things about the lockdowns and the COVID restrictions is it also dried up business opportunities for lawyers. If there are no cars on the road other than essential workers, there are far less car accidents. So just like when, as an industry, we saw the foreclosure crisis in 2008, and so sales dropped dramatically and many people turned to, let's say, rentals to start sustaining their business and maybe commercial, attorneys who can practice in different areas as well will start to look for different ways to sustain their businesses. And so then you get the creation of website accessibility claims and new players in the fair housing world that you haven't seen before. So they have evolved as well in terms of how they look at moving forward with their law firms, just like we evolved as a real estate industry when the market causes us to deviate from how we usually do business. And so as we talk today, you're going to see there are some new players in this space. They're the same attorneys, same plaintiffs, but there are some new faces as well. Next slide, please. So we know the Fair Housing Act well in our industry, right? We have embraced and celebrated the Fair Housing Act. We are committed to fair housing principles as realtors. That's who we are, as we say. And so we have adopted it in our code of ethics, even beyond what the law requires us to. We have additional protected classes in our code of ethics because we embrace fair housing. So, but let's talk a little bit about what the Fair Housing Act really means. It is a discrimination against a protected class, okay? And it can take many different forms. Bear with me just a minute here. It can take many different forms. It's not just about certain words. Usually, fair housing means that you are denying or limiting services or setting different terms or conditions, such as requiring pre-approvals or identification. Think about the Long Island, New York case where they said, you know, yeah, I'll take you to see the properties, but I need to see that you're pre-approved. And you say that to some members of a protected class, but not members of other races or, you know, non-protected class members. One we're going to focus on today for purposes of our discussion is advertising a preference, limitation, or discrimination, such as no children or no felons or no criminal history, or as we see in South Florida a lot, no Section 8, which is also a violation in South Florida, though not necessarily in all counties here in Florida. Steering based on racial composition of a neighborhood or using coded language. These are all forms of discrimination under the Fair Housing Act. But again, we're going to talk about advertising a preference, limitation, or discrimination. Preference, limitation, or discrimination. Next slide, please. So last summer, I mentioned we released an alert and a video when we became aware of the fact that there is a particular law firm in the state that uses a certain tester, right? Long Island, New York used testers. Testers are acceptable under the Fair Housing Act in both federal and state law. They are well recognized. They do not have to actually intend to rent 100 properties to sue 100 people. They can, in the name of testing a business for fair housing compliance, put you to the test and contact your business or test your services against the Fair Housing Act. And if you do not pass the test, you are exposed to being sued. So testers are a legitimate, recognized concept under the law. It feels wrong. It feels like entrapment, Juana. I hear that a lot, but recognize that testing has been for decades, since the inception of fair housing, a recognized form of enforcement of the fair housing laws, both by government entities and private entities and individuals, okay? So whether we like it or not, whether it feels right or not, testing is real and it's happening. So last summer, this is the exact slide I used in my presentation. And I said, y'all, we have a problem. Over the course of like a 5-month period of time, this Joshua, the attorney, and his tester, his client, Mr. Chambers, like they've sued, 30 plus people over the last 5 months from January to May, not just realtors, but also associations and businesses. So, this is a trend over 5 months. This is an alert, right? So we sounded the all call. Next slide, please. The next slide shows you that Joshua and his client, his tester, Mr. Chambers, they have turned this into an efficient, well-oiled machine. It's not 30 lawsuits in 5 months. This is December of 2020, 27 lawsuits in 1 month. They got this down to a science, y'all. And these are all real estate brokerages, every single one of them. 1 month. If every single one of these settled for $3,000, let's say, even if they don't go to court, that's a pretty good haul in the middle of a pandemic. Okay, there's a lot of motivation and incentive here. Okay, so how is it that this attorney, despite the fact that I have given this presentation, I don't know, Lamonda can tell you, I'm sure she's heard it several times. I think I've been to your board a couple of times to talk about this presentation at her invitation. I have given this presentation, I don't know how many times within this industry, me or a member of my team. Despite that, they are making a killing on this industry. You want to know how? Next slide, please. So back in 2016, start there, HUD issued a memo, guidance to the industry, to the housing industry. And they said, listen, there are 2 types of discrimination. There is intentional discrimination, where you say, I'm not going to rent to X, right? This member of a protected class. I'm not going to rent to this person who, because of their race, their national origin, their religion, their whatever the protected class is, fill in the blank, I'm not going to rent to them. I'm going to deny them housing. That's obvious intentional discrimination under the Fair Housing Act. The second category of discrimination is something called disparate impact. That is where the discrimination is unintentional but real. That is where, because of circumstances, realities about society, whatever the case may be, you have a policy that, though it is not intended to discriminate against a protected class, it has the effect or impact of discriminating against a protected class. So in 2016, HUD issued this memo. And this is well before any of our current social justice discussions or anything like this, years before this, where they said, so we've studied this, and here's what we found. We found that 1/3 of the adult American population, they have a criminal history of some sort. They've had some interaction on some level with law enforcement that goes beyond like a traffic ticket. And while being a criminal or having a criminal history does not itself mean that that is a protected class status, there are some realities of the criminal justice system. Minorities are more likely to have a disproportionate involvement with the criminal justice system. So long before this current discussion, HUD said, we've studied this and we realized that minorities have a more likely chance to have involvement with law enforcement, which means they're more likely to be arrested, which means they're more likely to have a criminal record, right? And so because of that, when you have a policy that says we will exclude you from this housing opportunity, if you have a criminal record, it has the effect of saying we have a policy that will exclude more minorities. That's the HUD study back in 2016. Okay, next slide, please. So whether we agree with that or not, you got to sit all that aside. That is the law. That is the way HUD has analyzed that guidance. And that is the disparate impact theory. Okay. And so under that theory, we'll talk about how you properly screen a tenant in a minute. But here's how Joshua and his client have gotten this down to a science. HUD feels that that policy, right, when you say no criminal history allowed, you are disproportionately excluding people of certain protected classes. When you say no felonies allowed, you are disproportionately excluding people of certain classes. So I want you to think about this for a minute. It is not that you cannot screen tenants for criminal history, but not all criminal history is created equal. Not all felons are created equal, okay? Within this industry, last year's keynote speaker at Florida Realtors Convention was a gentleman by the name of Weldon Long, who was a 9th grade dropout and a 3 times convicted felon. 3 strikes you're out kind of felon who spent time in prison. But in 2009, excuse me, was selected by Inc. magazine as one of the nation's fastest growing CEOs of one of the nation's fastest growing privately held companies. Got out, turned his life around, found himself on the stage at Florida Realtors statewide convention. That year before, NAR had a keynote speaker who's a pretty big name, who is a convicted felon, who they featured because of his incredible work in the housing industry in his community where he grew up, because he's given back to his community in Boston. And that gentleman, though he is a convicted felon, stood on our NAR stage and presented to realtors. His name is none other than Mark Wahlberg. And to me, one of the most interesting stories of convicted felon having done time in a federal correctional institute is one I would love to personally be able to brag lived in one of my properties, is a lady by the name of Martha Stewart. So as we go through this slide, I want you to think about Martha Stewart. Okay? I want you to think about Martha Stewart. So here's how these attorneys are making a killing. Remember, I said on that first slide about fair housing, it is a violation of the Fair Housing Act to advertise a preference or a limitation of housing. A preference or a limitation of housing. So here's what Joshua and his attorney, here's what they do. They did what I did. 5-minute internet search. How do we find our next set of cases? Okay, let me go to realtor.com on any given day, which is literally what I did in preparation for this slide. And I put in Florida as the search criteria. And I put in rentals as the search criteria. And I got 11,364 rentals available in Florida on that day. So since Realtor.com allows you to, and I'm not bashing Realtor.com, I love Realtor.com. I just go in there sometimes just to look at the houses because I love looking at houses, love their site. So I put in the keyword felony. And 10 results came up. And here are a couple of my favorites. The first one, must make 3 times the monthly income. Okay, that makes sense, right? Because you want to make sure they have sufficient money to be able to pay the rent. That completely makes sense. No felony convictions. Okay, Martha's out. She's out. Mark Wahlberg is out. They are no longer qualified to rent, right? That is advertising a preference. The next one, minimum FICO score of 600. Makes sense because you kind of want to make sure these people can actually afford to live there, that they pay their bills on time. That makes sense. No previous evictions. Completely makes sense. Or felony convictions. Martha's out. So are, according to that HUD memo, a disproportionate number of minorities who have had a disproportionate interaction with law enforcement. Okay, so they're out. Do not apply. This one is like a billboard. Do not apply. So we won't even consider you. We're not even going to look at your application. That's a problem. Do not apply if you have dogs. I'm going to come back to that in a second. Or if you've had an eviction or violent felony within 7 years. What's a violent felony? What does that mean exactly? That's a problem. Incidentally, so is using a term like do not apply, they say is, but I'm sure they meant if you have a dog, probably should say a pet if they mean no pets, because a dog can be a service animal or an emotional support animal, and that is another fair housing violation, potentially advertising a preference, okay? So then, this is the last one I love. Deal breakers are felony charges. Charges, doesn't matter if you're charged, it matters if you're actually convicted. There's a presumption of innocence in this country. My point is words matter in these advertisements. We have to be careful about these words. They matter in these advertisements. I did the same thing with the word arrest, because that should never, it's like charges. Doesn't matter if you're arrested. It matters if you've been convicted or pled guilty or been sanctioned by a court, not if you were arrested. And then I did a phrase, check for the word criminal. There were 318 that referenced criminal backgrounds. Most of them were fine, but not all of them, because the context matters. I personally would avoid the term criminal in all of my advertisements, but we're going to talk at the end about what you should be putting in your ads instead of the word criminal. All right, next slide, please. So I showed you the 2019 version of Joshua's, the attorney Joshua and his tester, Mr. Chambers. And I mentioned that, COVID really kind of caused some new faces on the scene. This is a brand new player on the scene that we haven't seen before. Got a call on the hotline about 2 weeks about this. This is an organization that has filed a lawsuit, not in federal court like Joshua and Mr. Chambers, but now in state court. So now we went from monitoring the federal dockets to see what's happening, which is easy because in Florida, you have the northern, the middle, and the southern district. You have 3 federal court systems here in Florida. Now we have to monitor all the state court systems to try to see what's happening, because now our members are being sued in state court for fair housing violations, which is permissible. We just hadn't seen a lot of that before. This is a new player on the scene, and I want to draw your attention to, this is their About Us page, and their home page rather, and it says, here at Florida Fair Housing Alliance, our goal is to lend accountability to the Fair Housing Act through investigatory testing to uncover discrimination in housing. That should send alarm bells off to all of you. Investigatory testing, that's like Long Island, New York, y'all. Investigatory testing. Next slide, please. And this is their About Me page. Being incarcerated for a decade, I had to expect many obstacles upon my return to society. One obstacle in particular was the reality that I could not get approved for housing and was getting automatically denied over and over again, like so many others. Okay? So that tells you that it's not just investigatory testing of just fair housing in general, and he is specifically focused on the fact that there is automatic denials. These advertising of preferences, don't even think about it, deal breaker types of advertisements that are violations potentially of the Fair Housing Act, depending on what your ad says. Okay, so I need you all to pay attention. The words matter. We're going to talk about those words in just a minute. Next slide, please. So this is what his typical complaint looks like. In this instance, this is an actual text from the lawsuit for the member who called the hotline. He is alleging that there was a Hispanic individual who was denied housing. Says here that that Hispanics are 3 times more likely to be convicted and incarcerated than white individuals. Sounds a lot like the HUD memo, right? Often they will cite the HUD memo in their material, in their lawsuit. So he goes on at the end in paragraph 13 to talk about prompted by an expectation of equal treatment or at a minimum fair consideration as a prospective tenant. Fair consideration at a minimum, right? That's all they want, fair consideration, which means you can't cut them off at the beginning. Fair consideration. Much to his surprise, Mr. Williams, however, defendant agent promptly informed Mr. Williams that defendant owner, and he goes on to say, would not consider his application if he has a criminal history. Okay, next slide, please. And so they charged, he cites the listing information, and he underlines in bolds for effect, no criminal background. That's what got him in trouble. That's what drew this attorney to him. No criminal background. That's the phrase that landed him on their radar, right? Not no criminal history, no criminal, just no criminal background is all he said. Next slide, please. 2 counts in this lawsuit. The first is a violation of county ordinance. So you gotta be careful, particularly those of you who operate in multiple areas, multiple counties. County ordinance now, right? Again, it was a lot easier when we were dealing with federal jurisdiction and the Federal Fair Housing Act. Now they're charging county ordinance violations. And every county may define protected classes differently. Multiple jurisdiction battle now we have in front of us. But what I want you to pay attention to here is defendant owner and defendant agent. 2 defendants here. This attorney is charging both the owner and the owner's broker, not just the brokerage. So it's not enough to just say, well, I was just doing what the owner said. You have to protect yourself. Okay, next slide, please. Count 2, interestingly enough, is a violation of the Florida Deceptive and Unfair Trade Practices Act. We call it FDUPTA for short. FDUPTA can be charged in a county court by lawsuit, but FDUPTA can also be the subject of a complaint to the Attorney General's office. Now, we have no idea of knowing whether or not this lawsuit has also resulted in a FDUPTA complaint to the Attorney General's office. We won't know that for some time, though we will look and try to carefully monitor to see whether that happens, because again, multi-jurisdictional assaults. Ironically, the same week we got this lawsuit, we got a phone call from a member who told us that he is defending a complaint for fair housing violations in front of the Florida Commission on Human Relations. They are like the state agency version of the FREC when it comes to fair housing complaints. So now we're monitoring Joshua and Mr. Chambers in federal court. We're monitoring the Florida Fair Housing Alliance in multiple state courts. That includes a FDUPTA claim that also be in the AG's office. And then we also now know that the Florida Commission on Human Relations has at least 1 complaint against a member for fair housing violations. This is why we're doing these sessions. This is why I'm so thankful for Jennifer giving me the opportunity to talk to you today, because this has become a multiple front assault. All right, next slide, please. So now that I've given you all the bad news, let's talk a little bit about how you do this, right? How do you do this and stay safe? It is perfectly acceptable to screen tenants for criminal history. Perfectly acceptable. I want to emphasize that. Perfectly acceptable. Perfectly acceptable. Back in 2016, when HUD issued that memo, NAR immediately issued do's and don'ts for you. And they still apply today. Here's how you do this. You want to create tailored criminal history-based policies and practices. Okay, tailored. You want to exclude individuals based on criminal convictions that pose threats to resident safety and property. So what do I mean by these things? Listen, if someone is an arsonist, you absolutely don't want to rent to them. They pose a threat to your owner's property. And that's acceptable. That makes perfect sense, right? If they are a sex offender and there are children in the neighborhood, it's okay to say no, right? If there's a school nearby and they're a sex offender, they're not supposed to live there anyway. So it's okay to say no to certain offenses because they pose a threat to the safety of the residents or the property. That's okay. But you want to have those types of tailored policies. You need to consider the nature and the severity of the individual's crime. So I don't make light of insider trading or whatever Martha Stewart's offense was, right? I don't make light of financial crimes because financial crimes matter as well. But you remember, back in the day, one of my first jobs was like a cashier. And I worked at a grocery store. And people would come in and, you could bounce a check in this state over a certain dollar amount, and it was a felony. Nowadays, banks have realized if you got direct deposit and we can count on getting that money in 7 days when your paycheck hits, it is profitable for us to charge you that insufficient funds fee and get that money when your paycheck comes in. It's a completely different world now financially than it was back in the day when you wrote that check and it would just bounce. And the sheriff's office would literally come and arrest people for felony bounce checks. Okay, so do you really want to exclude somebody who wrote a bad check back in 1981 and it bounced and they got arrested for that, when today they would just pay the insufficient funds fee to their bank and all is well? Again, a financial crime, but it's from 1981. Consider those types of things. Consider the amount of time that's passed, 1981. Consider the person's individualized behavior and file. How old were they when it happened? Were they 21 years old in college and celebrating their 21st birthday and being stupid? Or, were they 51 and should have known better, right? Evidence of good tenancy. They bounced that check in 1981, but since then they have like a 780 credit score and they have never been late on their rent, and they're an otherwise excellent tenant with great references. Is that someone you don't want to rent to? Meanwhile, you accept in someone with no criminal history, but they have a 610 credit score and an eviction from 11 years ago? I mean, this is what we mean by individual assessment, right? But here's the thing. Consider rehabilitative efforts like a Weldon Long, who has, despite being a 3-time convicted felon, reached the stage of Florida Realtors with such an inspirational story that we had to tell it to you, okay? Though that's what we mean. But here's the thing about this advertisement. You're saying don't even apply. So how can you consider an individualized assessment when you don't even want them to apply? That's the fair housing violation, where you put in an advertisement words that basically say, deal breaker, don't apply. Criminal history not allowed. All right. Oh, sorry. Next slide, please. Here's what you don't want to do. You don't want to use criminal history as a pretext for unequal treatment. That's pretty self-explanatory. Well, they got kids and I really don't want to rent to them anyway, so I'm gonna find, they have a misdemeanor, reckless driving from 10 years ago, so I'm gonna deny them based on criminal history, when really it's the fact that I don't like that they have kids and that's why I'm denying. That's what they mean by pretext. Do not provide inconsistent explanations for the denial of tenants. This is one of those where I wouldn't have these long, drawn out email responses for the denials. I'd have a form letter. If you don't have a form letter in your office, Encourage your agents to not put all of this sob story in writing. And encourage your agents to learn the art of passive voice. Your application has been denied. That's what I mean by passive voice, as opposed to I have denied your application. No. I have not denied anything. Your application has been denied. Or the owner has selected another applicant, right? But do not ever own the owner's decision or the association's decision. It is never the brokerage decision. And I understand that many of you think, well, that's what they hired me for. That is not why they hired you. They did not hire you to own potential fair housing violations. They hire you to screen tenants. Screening means gathering the information, but make it clear to the owner they need to decide. This is an area with lots of risk. This is one where you want the owner to decide. Do not create an exclusion based on arrest records alone. We talked about that. Doesn't matter what the charge was or whether you were arrested. It matters whether you were actually found guilty, convicted, or you entered a plea. Was there some finality to it that resulted in sanctions by a court, not whether the person was pulled over and put in handcuffs. Do not create an overly broad or blanket exclusion of any person with a conviction. That's what we talked about in this advertisement. Do not say no criminal history is allowed. That is an overly broad exclusion. You cannot do that. Do not use comparable criminal history differently for individuals of a protected class versus a non-protected class. So if you have someone who's a member of a protected class with the same type of criminal history as someone who's not a member of a protected class, you have to treat those people the same. And do not make exceptions for some individuals, but not others, even if they tug on your heartstrings, because the problem with that is you start to create a record that you're willing to accept, bend the rules for some, but not others. Even if that person is a member of a protected class and you want to bend the rules for them, that's going to be problematic. Now, if the owner wants to bend the rules, let the owner bend the rules. That's the owner's decision, but you don't do it. All right. Next slide, please. All right, so there we are. There are questions. And the last thing I will say in terms of the advertisement, a couple other things I want you to assess before I take questions. I want you at the end of this presentation, when you go back to your office, I want you to go back. I want you to look at your forms. I want you to look at your handouts that you give to your customers, particularly your listing information. And I want you to look at your websites. Do you have phrases on your websites that talk about background screenings? If you do, I want you to eliminate any reference to minimum background, criminal background requirements, such as no criminal history in the last 10 years, no felony in the last 10 years, no felonies, misdemeanors, blah, blah, blah. Okay, I don't want any of that on your websites. I don't want that on your forms. It is great when that plaintiff's attorney sees you're trying to say, well, it's the owner's decision, but then they go to your property management website and they see that you have programmed into your website, no felonies allowed. That's a problem. That tells me then that's not the owner's decision. That's your decision as an agent. So nothing about your website and your forms should specify no criminal history. I want you to consider your form letters and things like that. Do they use passive voice instead of active voice? Your application has been denied versus I have denied your application. I want you to review your applications, your websites for the word charges or arrests. Get rid of that language. Doesn't matter. You want to know if they've been convicted or pled or entered a plea. That's what you need to know, okay? In general, you want to convey, you are free to convey to people that they will be subject, whether it is a person buying a property and there's an HOA or condo association involved, or leasing, or advertising sales, right? You've got to start paying attention to your advertisement. But in the context of criminal history, I want you to say, comprehensive background check will be informed, including credit, employment, criminal references, blah, 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 whatever you do. Comprehensive background check will be performed. Evictions, credit, employment, blah, 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 blah. Okay, let me go ahead and answer this question. It doesn't matter if it's the association's prohibition. You are not the voice of the association. Don't assume their lawsuit. If the association does not allow anyone with a criminal history, then in your advertisement say, association will provide a comprehensive background check. Please contact the association for details. Okay? That's how you put the burden on them to convey their fair housing violation. Do not do it yourself. All right? For sales, those of you who don't do rentals, those of you who don't do property management or leasing, that's fine. Your advertisement is under scrutiny right now like never before. If you know, there are probably anywhere between 2,500 and 3,000 new sales associates coming into this business every single day, or excuse me, every single month. I need you to make sure that in your office, you have a way, a policy, something of screening, reviewing, spot checking advertisements that are going into the multiple listing service, that are being fed to the realtor.coms, the Zillows, the whatever, because these ads, that is what is causing your company to land on the tester's radar. Make sure your agents review. There is a video and an article that we wrote last fall. They are on the Florida Realtors website for fair housing advertisement. There are phrases out there, none that are sanctioned by HUD, let me tell you that, or NAR or Florida Realtors, but some that are very good list of red, yellow, and green fair housing words. I need you to get familiar with those. Okay, I haven't seen any bad ones or ones that I would tell you not to use. So I would say, just familiarize yourself with the concept that there are red words that you cannot use in your advertisements for sales. There are yellow words and there are green words. You heard a lot of talk last summer about, can we use the term master bedroom, right? NAR said master bedroom's fine. But there's a lot of discussion right now. Can I use the term walking distance to? Probably shouldn't, because people who are in wheelchairs might take offense to walking distance to. Don't reference types of religious facilities, even if you're just trying to use it as a marker. Walking distance to the, certain name synagogue. Maybe it's just a place in town that everybody knows. And so you're trying to send the message that it's close to downtown, but pick another landmark that is not a religious facility, because people will think that you're trying to advertise to a certain religion and exclude others, right? These are the mistakes that we are seeing out there that are tripping people up because they're not thinking about the contents of their advertisement. Walking distance to, no, don't say it. Say close proximity to, or approximately half a mile to the Publix or the grocery store, okay? You've got to get smart about your ads. That's the takeaway here today, whether it's criminal history or other fair housing words. All right, now I'm going to shut up and answer any questions that you have. Let me have questions about anything, that or anything else.
I actually have one for you, Juana. It's Jennifer.
Yes, Jennifer.
With regard to the lawsuits that you have seen, that you discussed, especially with regard to the more recent ones, I know that they are focusing their attention on the brokers, but is it going beyond the brokerages? Is there personal liability or no with these agents? Is there liability that goes up to the local association? Is there liability that keeps going up and up and up?
So that's a great question, Jennifer. Let me tell you, rarely will the agent be charged, will be sued. The agent is not the deep pocket, and they know this, right? So it's usually going to be the brokerage that's charged. Sometimes it'll be the agent and the brokerage, but usually it's the brokerage. So this is why it's really important for brokers to hear this and to get this, because it's them. And then they call me and they're like, but I didn't even know okay, but I hear you. But they are on, and then we there are things that the brokerage can try to argue in terms of, independent contractor status and things like that. So it's possible. Can it rise? Can it reach the association level? Usually we don't see that with the association, but here's what I would say with the association: be careful. This is one of the reasons why I am not a fan of these Facebook groups and things like that. If the association runs these private Facebook groups where members share this information and, there are fair housing violations happening on these pages, could the association probably, be perceived as facilitating fair housing violations? Potentially. I mean, there's an argument there, right? And so that's why you just have to be careful when you facilitate those types of discussions, because yeah, you could be at least caught up in it. The question is not whether or not you can be ultimately successfully sued, right? The issue then becomes, do you put yourself in a position of being sued initially, like involved in it to begin with, and just the pain and expense associated of trying to get yourself out of it is bad enough, right? And that's why, on a federal court level in particular, 96, 97% of the cases settle, not because 96 or 97% of the lawsuits are meritorious and ultimately would be won, but it's so expensive and time consuming and painful that most people write a check and make things go away, right? So the point of risk management is you want to insulate yourself from being sued to begin with, or at least creating enough of a barrier that you can successfully and more easily get yourself out of the litigation. And you do that with things like this, Jennifer, with training, with making sure if you're a broker, your agent has policies and procedures and knowledge and understanding of how to do these things, so that you can say, listen, I told them, Judge, but they ignored, the information that I gave them. It's not about control, because we don't want it. They're independent contractors, but it is about knowledge and understanding. Any other questions? Anything? The last thing I will say, if we don't have any questions, is what I'd hoped to move on to this year was antitrust training, because we did a lot with fair housing last year, and I'd hoped that this would be the year of antitrust, because it's such a hot topic. You know, members have a lot of questions about it because of the NAR lawsuits last year, and then the DOJ announcement. So I hope that you can look for some resources in the near future on antitrust for me and my team. It is an important area. I encourage you to take a look at some of the NAR resources on antitrust. It is very, very, very important because it's another issue, area of emerging risk. So, you know, without getting into it today, just please, please, please avail yourself of the NAR resources on antitrust, particularly if you are a broker or an association, and make sure that you learn as much as you can about that area as we look at these new changes that come about as a result of the NAR DOJ order that will be finalized in the coming months. And that's all I have. If you don't have any questions, I just want to thank you all so much for your time. I wish I was there with you in person. I love coming to see you guys. You're amazing. And Jennifer, I appreciate this opportunity. I really do. I want you all to stay safe from COVID, but I also want you all to stay safe from liability.